Hello, I'm Chryssa Mela. I'm a legal officer with Fair Trials, and today we're going to discuss a current project we're working on, flight risk. Flight risk aims at assessing judicial assessment of flight risk at the National Institute for Criminology and Criminalistics in Belgium. Have authored a report on the available statistics and research on flight risk that we're going to discuss today.
I'm Maes. I'm a senior researcher at the National Institute of Criminalistics and Criminology, and together with my colleague Alexia Jonckheere, I co-authored a report on available statistical data and research concerning flight risk and pre-trial detention proceedings.
What is flight risk, Eric?
Yeah, flight risk is in fact an additional ground for opposing pre-trial detention. So besides the fact that there must be a reasonable suspicion that the suspect has committed the offense and some special requirements regarding offense type or severity of offense or the sentence length and the expected sentence length that can be imposed. There are also most of the European legislations, there are also some additional grounds for imposing pre-trial detention. And there are three categories of additional grounds. One refers to the risk of reoffending, the risk of recidivism. Another one refers to the risk of collusion or tampering, the risk of tampering with evidence. And another one is the risk of flight. In a strict sense, the risk of flight refers to leaving the country with the objective to evade justice. But in the literature and in the legislations and the legal practice, different terms are used. For example, risk of absconding, risk of fleeing, risk of hiding. Especially very interesting in the German legislation, there's a very clear distinction is made with regard to flight risk. The Fluggefahr refers to two concrete actions, separate actions. First of all, there's the fleeing. This means risk of absconding, and besides that, there's also another ground. It's the risk of hiding, zich verborgen houden.
How was the process of retrieving pan-European data on flight risk and pretrial detention, and how well does Europe document pretrial detention and flight risk?
Yes, the aim of the project or the study was to get an overview of the available national official statistics on the use of flight risk and pre-trial detention proceedings. So to have an overview of the official statistical data and also about the research that was conducted in Europe on the use of flight risk. So we collected for this, in order to get this overview, we used two data collection methods. First of all, we conducted a literature review. This was mainly based on a review of articles published in English in 5 European international journals, criminological journals, where we looked if there are some articles available on pre-trial detention and on flight risk in particular during the last 15 years. Besides that, we also knew that there was already research going on or finished with European Union funding, for example, the DATO project and the pre-trial project. And so this was the first method, as a literature review. And a second method that we used to collect the necessary data was that we developed a questionnaire. And the questionnaire refers to questions about the legislation in a particular country, but also about the practical use of pre-trial detention alternatives and the use of the criteria of flight risk. So we developed a questionnaire, we sent this out to experts or possible correspondents in all the European Union countries. And we received also a response rate of, we received from every country, we received a response, so a response rate of 100%, which is very nice. And we're also very grateful to all the people who helped us with collecting this data. Now, if we look to the official statistics, there are already some interesting statistics which are published in the annual reports, Space 1. These are data that were collected by the University of Lausanne on behalf of the Council of Europe. And in these reports, you will find very interesting data on prisoner populations and also on the prison population and pre-trial detention. There are several tables that refer, for example, to the number of inmates, the prison population, also the number of pre-trial detainees, the population divided by gender, by nationality, by legal status, by status of residence. There were also, for example, statistics on the releases from prisons, inmates who died during detention, the average length of imprisonment, and also the expensive and penal institutions. So there are also already some statistical data that are very interesting with regard to pre-trial detention, but specific data or official national data on the use of the grounds for pre-trial detention are almost unavailable. Only in Europe, only in Spain and in Germany, there exists some specific national official statistics on the use of the grounds for pre-trial detention. If you look to the research, there's very little research done, not so much research done on pre-trial detention if you compare this with other criminal justice related research topics. As I told you, there were some research that are done via funding of the European Union and which are very interesting also.
Despite the numerous directives on procedural rights and cross-border cooperation in criminal matters, there is still no harmonization in Europe regarding flight risk and pretrial detention. But based on your research, what do statistics tell us about these issues, pretrial detention and flight risk?
Yes, besides exception of Germany and Spain, where there are national official statistics on the use of the grounds for pretrial detention, there are no other countries who have the same type of statistics available on a nationwide basis. What we learned from the German experience is that there's a publication by the Statistisches Bundesamt, and what you learn from that is that in most of the cases, more than 90% of the cases, the pretrial detention is grounded on the risk of flight. It's also confirmed by the research literature on the German situation. But what is interesting to find out is that the grounds are very differently used according to the specific jurisdiction. For example, in Germany, it's a flight risk that predominates. But if you look to a neighboring country, Austria, there it's more, the pretrial detention is more based on the risk of recidivism. So there are also very big differences between different jurisdictions within the European Union. There may be different explanations for that. First of all, there may be a legal restriction. For example, in Austria, it's more difficult to base pretrial detention on the ground of flight risk, because people who have a residence in Austria, and if the expected sentence is not very long, or it's up to 5 years, then there may not be assumed that the person can be put in pretrial detention. So that's a legal restriction specifically for Austria. Another explanation can also be that there's a different orientation on how to use pretrial detention. For example, to what purpose serves the pretrial detention? Is it for securing proceedings, or is it for securing society? And if it is for securing society more, and it refers more to the risk of reoffending, if it is about securing the proceeding, then there's more the risk of collusion or the risk of flight that is more important.
Well, Fair Trials has also drafted a regional report on flight risk, and we specifically looked at the standards that the European Court of Human Rights sets for the assessment of flight risk. Article 5 of the European Convention of Human Rights addresses the limitation to liberty in regards to flight risk. And it also sets the requirement of a test of reasonable suspicion that makes detention necessary for the person not to flee, not to fly away. And when it comes to the reasonable suspicion tests, the guide on Article 5 explains that what we need is the existence of facts or information that would satisfy an objective observer that the individual may have committed an offense. So based on your research, what facts or information are taken into account when assessing flight risk?
Yes, one of the main or most common critics on judicial decision making in pre-trial detention proceedings is the fact that decisions are most often not really substantially motivated. So, but what we learned for the research literature is that there are mainly three big categories of elements that are taken into account in the assessment of flight risk. The first one is the severity of the offense or the expected sentence length that can be affected or influences the use of flight risk in this kind of proceedings. The second element is to what extent does the suspect has sufficient ties with the community of the prosecuting states, for example, family relationships or regular occupation. And a third aspect or a third element is nationality of the suspect and more particularly the lack or the absence of fixed residence in the prosecuting state. That you will see also in the prisoner populations in some jurisdictions, European jurisdictions, there's a huge overrepresentation of foreign nationals in the prison population. And this has also to do with the fact that the person has not a fixed residence in the prosecuting state, and that magistrates or judges do not really trust the imposition of the alternative measures.
Thanks a lot for the discussion.
Okay, thank you very much. It's a pleasure.